Okay, guys, in this EP, it will be about vicarious liability. And the vicarious liability arises in the situation where a person has committed a tort, and then there is another person who has a relationship with the person who committed the tort, has to be jointly liable with that person. Okay, even though this person is not doing anything related to that the commission of tort. So if you that there are many situations of vicarious liability under the Thai Civil and Commercial Code. However, the ones that we are interested in the context of media law, specifically, I would talk about the vicarious liability for the situation when the employer must be jointly liable with the employee for what employee have done. If you see this, if you take a look at this slide, so Section 425, an employer is jointly liable with his employee for the consequences of a wrongful act committed by such employee in the course of his employment. Section 426, the employer who had made compensation to a third person for a wrongful act committed by his employee is entitled to a reimbursement from such employee. So the idea here of the Section 425 is that as the employer, okay, the employers must be jointly liable with the employee for what employee has done in the course of the employment. For example, if you are the employer and then you hire an employee to work as your driver, for example, the truck driver, and then in your business you might have the business of like distributor, or you are the you sell many products and you have the truck driver, okay, in order to make a delivery of your products to the customers. And in the course of business or in the course of the employment, the driver has drive the truck and then hit somebody on the street. And when he hit somebody on the street, is on the way to deliver the product to the customers. So you see that the truck driver is doing this in the course of the employment, right? Because to deliver a product to the customer is originally from the order of the employer, right? So it's kind of the work of employer, but it is done by the employee. So the law think that even the employee is the person who committed a tort, but the employees act in for the employer's interest, right? And another reason is that employee might not have the capacity to pay all the compensation, right? It's because normally the employee is the one who has like more money, right? But the employee could be the labor or the daily worker who has like the who has not enough money to pay for the compensation. So that's why we have the employer here to pay. The law used the word jointly liable. This means that both employer and employee must be liable together, okay? Must be liable together. And in the context of the media law, it is possible that the employer will be liable with the employee as well. So in this case, this case is a good example. It is the case of the Thai Medical Center versus the Nation, which is one of the news reporter, right? Back in around 10 or 15 years ago, okay, this case is from the article, the news article written in the newspaper. And there was the phrase, there were some sentences that I captured from the court decision here. The writer of the news article, sometimes we call columnist, the hospital became slaughterhouse. The doctor working there were bandits in white uniform. So this is kind of defamatory statement because it's in contrary with the truth, right? How come the hospital became a slaughterhouse and the doctor there um, were like bandits? Okay, so this case, if you are interested in the why the reason why the writer of the news article wrote something like that is that the fee of the hospital, the writer think is too high, and uh, he thought that the service there is not that was not that good. So he said the hospital became the slaughterhouse. But at the end, the court decided that this case, the writer of the news article is committed defamatory, the tort of defamatory, because of that untrue statement. Okay, written in the news article. However, the issue is that uh, in this case, okay, in this case, there are more than one person, more than one people that the hospital is sue the employer, like uh, the company. Okay, a columnist who is the the writer of this new article, and the editor who is normally responsible for all the contents published in the newspaper, right? And what the court is said here, the court's holding is that the columnist who wrote was held liable, okay, as the wrongdoer, and then the editor could not deny his responsibility, claiming he only reviewed the first page to waive this liability. So it's kind of it seems like the editor has the duty, right, to take care of to be responsible for all the contents. Okay, so the editor is supposed to review all the content before everything is published. That's why the court denied, because the editor tried to raise an accuse that the editor has not seen any content about that, because it's inside the newspaper. Because in the newspaper, there are so many pages, right? The editor cannot look like every line on every columns, every articles. The editor cannot look take a look for all of that. That's why. But the court denies such excuse, and then the company, as the employer, must be jointly liable as well, because what the editor has done. I mean, like the editor wrote the article, right? This is in the cost of the business of the employer, right? Because it's in the cost of the employment, right? Because the nation company has hired this editor, right, to write down the articles in the newspaper, right? And this is in the cost of the employment. That's why the nation company has to be jointly liable with the writer. Okay. This is another case. If you know her, she is the Miss Universe, right? Around like 30 years ago, and this is the case between Khao Sot and Kun Pon Tip. Okay, and this the defamatory statement was found in both the news headline and also the content within the article. And the article say that Kun Pon Tip will be undressed for the nude photography, and with the condition of being paid for the amount of like 5 million baht, which is not true. And then Kun Pon Tip sue the newspaper, the Khao Sot. And then the plaintiff asked for 30 million baht compensation, but the court granted only 1 million baht damages. Okay, not too much, right? And this case is also interesting because this is the case in the U.S. Okay, so the Jerry Falwell. If you okay, I'll try to show you what happened here. So Jerry Falwell talks about his first time. Okay, so briefly, if you read the whole content, okay, first time you see the headline of this article when someone talks about the first time, what do you think? Okay, with a little bit dirty minds, you're gonna think about the first time of having sex, right? That's what normal people gonna understand, right? But in this one, in this article, what it means is that the first time drinking an alcohol. Okay, but okay, if you read the content here, okay, between the Falwell and interviewer, but all the conversation is fictitious, so nothing is true. Okay, nothing is true, but it is used for the advertisement. Okay, the Falwell, my first time was in the outhouse outside Lynchburg, Virginia. Wasn't it a little cramped? Not after I kicked the goat out. Interview, I see, you must tell me about that. Falwell, I never really expected to make it with mom. So, first time, right? I wrote it. Even like reasonable person gonna who read this gonna understand that he having sex with his mom for the first time, right? But at the end, you're gonna see that what he means for the first time is to drink the alcohol. This brand of the alcohol. And this is part of the advertising campaign for the brand Campery. Okay, and see, Campery, you never forget your first time. Okay, and at the very end, at the bottom of the page, it says that this is a parody, not to be taken seriously, right? And after this article is published, okay, after this article is published, Falwell brought the case to the court against the magazine who published this, saying that this magazine has committed the defamation because this lead to the misunderstanding of the Falwell that he had sex for the first time with his mom. Okay, however, what the court says is that even what is written in the article is not true, right? But no one gonna take it seriously because it is like it is fictitious, right? It's just a fiction. Okay, and at the bottom of the page you can see as well, this is just a parody, not the assertion of facts or the circulation of fact, which is untrue, right? Everybody gonna understand this is not, this is never a fact, right? It's never a truth. Okay, it's just a parody. Okay, so this is the language used by the court. As the public figure, Falwell was prohibited from recovering damages for the tort of intentional infliction emotional distress, a parody or satire of the public figure that a reasonable person would not have interpreted as factual does not constitute a defamation. See, so here in the ad parody, even they use the false statement. Even they use the false statement is not a defamation because no one gonna understand this is factual, right? So this is the reason given by the court. Okay, so this is a little bit different from fair comment, right? Because the fair comment, even it is based on the the untrue statement. Okay, it's gonna be the defense, but this one, I think, it does not meet the first element of the defamation, because the first element is there must be the assertion or the circulation of fact, which is in contrary with the truth, right? But this one, everybody can understand this is not a fact. This is not a fact. This is just a fiction. So the reputation of the Falwell is not going to be ruined because of this. Okay, this is just the part of the advertisement of the brand. Okay, so this is okay to protect the creativity of the advertiser. Okay, if we take into account two interests, like the interest of the Falwell and interest of the I would say freedom of expression, this one freedom of expression prevails, okay, because it does not really ruin the reputation of Mr. Falwell, okay, especially he is a public figure, okay, everyone he is known, he is a public figure, so everyone knows him well, and just the fiction here, it's just a parody, so it does not hurt any reputation of Mr. Falwell. Okay, no one gonna understand really that he had a sex with his mom for the first time, something like that. Okay, all right. So how to avoid defamation liability? So after you have learned all the elements of the defamation here, the way you can avoid defamatory liability is try to if you have to make a statement, or if you have to write down, or you have to report the news, okay, you might think of these ways, these measures to avoid the defamatory liability. First of all, as long as what you say is true, you will be okay. So under section 223, okay, the most important element is that the statement you made, okay, must be contrary to the truth, right? So as long as you say that what you say is true, you're gonna be okay. You are not gonna be liable for defamation. Okay, avoid assertion of fact when you are not sure. So one way that you can make a statement is that you are not sure what happened. Okay, you might think of, I'm not sure this happened or not, but there is the news that this person has done this, done that. But you can avoid asserting that this fact happens or this occurs actually, something like that. Okay, so that's another way. And another thing is that to make sure even you might injure another person's reputation, you are able to raise the fact and defense. So when you have a comment, make sure that it is fair. Don't make up some facts, okay? Don't make up a fact that you don't really know is true or not. So this is gonna help you avoid the liability for defamation, okay? Then defamation in cyberspace. So as I have told you already, that the defamatory statement could be in various forms, right? It could be in writing, it could be done orally, it could be included in even a play, right? So cyberspace is a virtual world where you can go online, right? And you can connect to everybody in the world. So everybody in the in this world, especially in the social media platform, okay, you are a content generator. You can be the content generator because you have the smartphone. You can capture anything. You can create a clip. You can record your voice, anything. Okay, so everybody in the world with the smartphone, with the devices, okay, can make a statement, right? Can make a statement, and those kind of statement would, if it's defamatory, of course, that person might be liable, right? Okay. And then when we talk about the platform, right? Talk about the platform, and if the defamatory statement is published in the platform, who will be liable for that? Is that going to be the content generator, or is that going to be a platform? For example, if you post something in Facebook, okay, and you post the statement that you know is not true, okay, so you are the first person who is going to be liable, right? How about the Facebook? I would say in this case, Facebook doesn't know anything, right? And the Facebook has just provided the platform, right, for you to post the content. So to hold the Facebook liable is kind of unfair, right? So If a person is just, in this case, as the publisher, the creator of the content, okay, this person must be liable. But as the distributor or just the common carriers or conduits, it's just the channel for communication. This person are not normally liable. Okay, are not normally liable, as well as the internet service provider, except the internet service provider is the has known this is untrue and then still distribute this again and again, something like that. Okay, so this is some questions. For example, does click like constitute a defamatory statement? Okay, so by clicking like, you can see that even you click a like on the statement which is not true, it doesn't mean that you agree with that, right? So I would say that just clicking like cannot constitute the tort of defamatory, okay, because it's not the assertion or the circulation of facts. Okay, it does not constitute. However, the share a little bit different. If you share the content which is not true, normally you are not going to be liable except you already know such content is untrue. Okay, so it depends. Then this is another popular case between Captain and Bing, right? And that's you might know better than me what happened in that case, right? So there was a case between them, and they're saying something untrue, and this is a good example of defamatory statement. But from this case, I just want to you to think about, what if you are the news reporter, how to avoid the defamatory liability. Okay, so think about this the slide before, right? Try not to assert or circulate the facts, right? Try to avoid saying this happened or not, right? Try to make it a little bit ambiguous, even this is true or not. Okay. All right, and this is all